Reading cases, an overview. In this series of videos, we're going to walk through the process of reading a case. In the context of legal education, a case refers to a judicial opinion. Now, judicial opinions are just one genre within the entire universe of legal writing, kind of like how short stories are one genre within the universe of fiction writing, except that reading a case is nothing like reading a novel or a short story. Learning to read judicial opinions and to understand and to analyze them is a specialized skill, and it's the very first legal skill that most students learn in law school. It's a foundational skill, one that is very important to a student's development as a lawyer. Over the course of 3 years in law school, a student will read hundreds of cases. Over a lifetime as a practicing attorney, he or she will read thousands. Most of the judicial opinions that you'll be reading in law school are found in casebooks, which are compilations, by subject matter, of judicial opinions. Most cases in law school casebooks are appellate records of appellate decisions, that is, typically at the lower court level. For example, say the trial court. There was a ruling that disposed of the case, and the disappointed party has asked the higher court, either an intermediate court of appeals or the highest court in that jurisdiction, to review the lower court's decision. Interestingly, research has been done showing that expert readers, that is, practicing attorneys, read opinions differently than do novices, that is, most law students. And probably more important for you, this research found a relationship, a correlation in fact, between those students who remained at the novice reading level and lower grades. So, if the importance for your legal career after law school of knowing how to read judicial opinions seems way too remote and way too abstract, understand that mastering this skill now will have an enormous impact on your performance this semester and beyond. There are some conventions that apply to judicial opinions. Most opinions, particularly those from the last 40 years or so, follow a very basic format. Of course, there are variations as each judge writes in his or her own style, but for the most part, judicial opinions track the process of legal reasoning, and that process is remarkably standardized in our legal system. Before we get into the specifics of that basic format, let's take a look at the name and citation of the case. Depending on where you find the case, a casebook, Lexis, Google, you might see a slightly different format, but will have the exact same details. The name of the case is that of the two parties suing each other, or the first named party if there's more than one plaintiff or more than one defendant. The case citation indicates where the official version of the case is reported. The first number is the volume number. The abbreviation indicates the series of reported opinions. And the final number is the first page number of the case. Typically following the citation, there's a parenthesis that contains the abbreviation of the court whose opinion it is and the date of the opinion. In the typical textbook case after the citation, the first thing you'll see is the name of the judge who wrote the opinion, followed by the opinion itself. And now we get to the format of the typical opinion. Keep in mind that individual judges may order the elements differently, and some judges may omit some elements entirely. But most judicial opinions contain the following elements: facts, procedural posture, issue, holding, rule, analysis, and outcome. Each of these elements will be covered in more depth in later videos, but what follows here is a brief introduction to each. A statement of the facts that gave rise to the dispute. These are things that occurred prior to the lawsuit being initiated. The statement of facts might be very brief, or it might go on for pages. The procedural posture or history of the case. It would be a mistake to think that judicial opinions are only written when a case has been finally decided. A judge can be called upon to write an opinion at any one of the various stages in the litigation process, from right after the filing of the complaint until the final level of appeal. Most, but not all, of the cases you will be reading in the first semesters of law school come out of the appellate process. Other common instances where a judge is called upon to write an opinion are to decide a motion to dismiss or a motion for summary judgment, both of which can occur fairly early in the litigation process. If the lawsuit was tried by a judge rather than a jury, known as a bench trial, the judge will have to write an opinion justifying his decision. Cases decided by a jury are different. Juries do not have to write an opinion to justify their verdicts. The issue or issues. The issue refers to the category of legal problem involved. Some cases involve a single issue, while others present multiple issues. If we look at it at a macro level, issues can be sorted by subject matter: torts, contracts, criminal law, and so on. Obviously, for each class, you will be looking at issues within that subject matter. Now, the issue is always stated as a question. Issues can be stated broadly, but who wins is way too broad, or more narrowly, but always as a question. The holding. If the issue asks the question of law to be decided, the holding answers that question. So if the question or issue is whether there's a contract where a seller delivered goods but there was no written contract, the holding will be either there is a contract where the seller delivered goods without a written contract, or there's not a contract in that situation. The rule. The American judicial system is based upon the concept of the rule of law. Briefly, this means that judges typically decide cases based upon pre-existing rules. There could be instances where a court is asked to decide a novel issue of law, but these are rather rare. Except for those rare cases, the judge is never free to just make up what the law is. The judge is always applying pre-existing law, either in the form of a statute passed by a legislature, state or federal, or a statement of law in earlier cases that decided the same issue. When a judge relies on a statement of law made in an earlier case to decide the present dispute, we would say the judge is using precedent. The analysis. Rules are not self-effectuating. When applying a pre-existing rule, the judge must decide what result that rule calls for. Moreover, the judge typically has to enunciate the reasons why the judge decided that the rule requires this particular result. The analysis, or reasoning section of the opinion, is where the judge, in essence, defends her holding in the case. Now, you will be expected to be able to paraphrase the judge's reasoning. It's not enough to know what the judge held. You must be able to articulate why the judge held that way. And finally, the outcome. The outcome differs from the holding. The holding answers the question posed by the issue. The outcome tells us who won, judgment for the seller or judgment for the buyer. So to wrap it up, when you brief a case, you're going through the process of identifying these elements in the judicial opinion that you're reading.